Reason my love. Both is memo where they go to widows my love. English law that passed a judgment allowing family pension to them, but the government after limitation finds appeal but not taking any action to restrict and pass an order. Both are my love. Family pension
There is no stay, sir.
Government is filed appeal my love. But they are sitting.
But there is no stay order.
But officer said we file appeal my lord. Not after appeal order we will do.
You understand what?
Yes, my lord. Yes, my lord. But they are the officers, they are the writ appellant, my lord. So they say we file appeal, not take action, my lord. So any day, my lord, admission so that. Yes. Oblige, my lord.
I am suddenly after 15 years of service, I am reverted. That is a result. I am reverted.
Disciplinary proceeding.
No, no discipline, just like that, without any natural justice. That I filed it.
My lord, due to this pregnancy of this writ appeal, my lord, I am being deprived of my livelihood since 2016, my lord. My lord, my termination was set aside by the single bench, my lord. But they have filed the writ appeal and they are not taking any steps for listing up.
We are not saying, but do one thing, because what is the normal practice is when you are a respondent and mentioning the matter, please mention after giving a notice to the experienced lawyer, so that at least he will be able to know that you are mentioning the matter in the district. Please do that so that at least he will come to know.
My lord, if you lordship will allow, I can intimate the counsel for the appellant.
You give, but give a notice to him.
Yes, my lord, I will definitely.
It may not be a surprise to them that suddenly the matter has.
No, my lord, I will intimate my advocate on
Where
it.
would the lordship designed permission beg to mention that this restriction was there in the list, but now this has been delisted. Well, my predicament is that my account has been attached. May I pray the lordship's kind permission
or what?
My lordship said, may I pray with the lordship convenience and it be listed on 2nd of April because 2nd of April.
You just pass on the slip, let us see what is the convenient time and a date we will definitely visit.
My lord,
Please tell your advocate and record to inform the other side.
Face matter, my lord. GST has been demanded and the appeal has been rejected. The demanding authority may attach my bank account any moment. Trace admission matter.
my lord, pardon to mention. Pardon to mention, my lord, illegal termination of laboratory technician, due to offense, my lord.
What?
Illegal termination of laboratory technician.
Laboratory technician.
Technicians, my lord.
It will appear in due course.
My lord, case study is a retaping, my lord. Case study is a retaping. The appellant challenging the order of the single judge application report for this matter regarding appointment.
Appointment. So it will appear in due.
Let's it's a matter of restoration business.
My lord, my lead appeal 66/2017 may kindly be articulated here. I already informed the opposite party, I'm the appellant. Yesterday I already informed, so kindly list as well. Oh, it is actually I was a faculty in the opposite party university. They terminated me just after the order of the Honorable High Court after a month by an alternate route. So I challenge the decision, the single bench. Single bench again uphold their decision without upholding the statute, rule of law, etc. So that's why
I want to mention your lordship. Lordship, both the matters are tagged, but it is not being listed, your lordship, for fresh admission. But the matters that are subsequently filed in subsequent dates, that they are listed, your lordship. Lordship, kindly take a.
Peremptory order has been, peremptory order was displayed on 18, and it was not displayed subsequent event. And we have been telling that matter may be taken up. Okay. Peremptory order. In this case, government will take instruction in that.
Finally, to mention one thing. It's a Jagannath temple matter, madam. And the settled position of law by this honorable court is that no post can be outsourced, my lord. Any post of the Jagannath temple cannot be outsourced. And the administration has outsourced some posts, and the recruitment process has already been started. And this was already in the list, madam. My lord, it's a little.
The appeal against the single bench arises out of no confidence motion. The wrong interpretation of section 24 of the GT Act violated, and I have asserted it's a clear wrong interpretation with all respect. But it was before the assigned board, but due to paucity of time could not be taken up. Since the assignment likely or these are writ appeals, my lord. No confidence, and they may at any moment declare casual vacancy and go for pre-selection.
Pardon to mention, your lordship. Your lordship, there was a judicial order for this matter to be listed on the 2nd of December 2024. Despite the same, the matter has not been listed. The urgency is that the post that the appellant wants to be reinstated against is presently lying vacant. If in the interregnum the post gets filled up, then the appellant would be gravely prejudiced.
If I may be publicly mentioned, the Orissa Public Service Commission has filed a writ appeal. The learned single judge has granted me a last chance to obtain an interim order in the well, on 29th of January 25, the first order. Once the court was informed that that a writ appeal has been filed, this CONTC number 4438 or 24, that is at the top. Request has been acceded to. Well, let's kindly see the second order. Order on 19th of March 25. As a last chance, list the matter in the week commencing 7th of April. Well, it was there in the list, but it could not be taken up due to paucity of time. Well, I'm great.
My lord.
My lord, this is our cover case, and the list already there, and the counter claims will be taken also.
Are you sure? Who is your?
Oilas Kevi and Mr. Das.
No, is it in the list?
Sent on list is there.
You know why you are mentioning? No. any modification?
Yes, your lordship. Serial number. Serial number cancel. 29 and
Your Lordship, that's the non-constitution of the tribunal.
Okay,
Your Lordship, yes.
and registration cancel. Lordship. Yes, yes. Yes, lordship already.
Modified order will not be acted upon.
Lordship.
And it's item 39 to 40. Item 39 to 41 of today's is permitted to withdraw.
Withdraw.
Yes.
If I remember.
Yes, ma'am.
You are adequate to the court.
Yes, ma'am.
Madam. Item 6. Similar notice.
This year, madam, just read. Other side is here.
Yes, ma'am.
Ensure the presence of the other side.
Yes, sir, I will.
I don't have 14 and 15 for you to withdraw. But you would
Withdraw. Withdraw matter. 14 and 15.
14 is.
It is already.
It is all, yes.
Your Lordship.
14, 15. Who are there?
Your Lordship.
Press admission item number 2.
No, that is not been received on that 18/6/2020.
Can you be a founder?
So minor girl has not yet been rescued. 18/6/2022. The state has the several time and for adjournment. The I am the appealing for petition.
So you want to move your matter? This is Patnaik, what is I-8?
That is fine. Integrated anti-human trafficking unit. Integrated anti-human trafficking unit.
Age of a girl.
15 years.
Who was in any matter related to a woman or a child. Do not make it a license matter.
He has filled up that he has received the copy. Your Lordship may kindly, on the date of filing of appeal, Your Lordship, the last para 2 lines below. On the date of filing appeal in form VAT 501 in column 6, it is mentioned that they have received the order on 29/5/2018. But on the date of hearing, they take the plea that the managing director of the company came to know about the aforesaid order only on 28th March 2019. Basing on only this ground, the appeal has been rejected, Your Lordship. I leave it to Your Lordship.
They are saying
Your Lordship.
that some lower down entry may employee in the office. Miss the matter. Or list.
Your Lordship, yes. Only this much I have to submit.
Sure. Under OBDT Act 2004 is dismissed by the appellate authority solely on the ground of delay in preferring the same. it is the specific stand taken by the appellate, the copy of that the order included in the said appeal was not within his knowledge. It was not within the knowledge of the managing director of the company. And the delay was necessitated on the ground of lack of communications. The appellate authority proceeded to dismiss the said appeal, relying on the information furnished in the format
Statutory.
which has a statutory recognition that the said order was the said order was received way back on 29th May 2018. We do not find any fetter on the part of the appellate authority in controlling the delay. In absence of any embargo having created in respect of a timeline. We are conscious that the authority must decide the matter on merit and should avoid the dismissal of the appeal on the angle of limitation. The court encourages the disposal of an appeal on the basis of the facts and the law involved therein. And if the delay has been sufficiently explained, despite a minor lapses or the latches on the part of the litigant, the court must take a pragmatic view in this regard. We find that though it is indicated that the order was received on the date as aforesaid, yet the person who are in helm of the affairs and manages and controls the affairs of the company was not communicated this said order, occasioning the delay in preferring the said appeal.
With respect, these finding your lordship, everybody will come and take the same plea that my employee has received the copy and they have not handed over to the responsible person, your lordship. Your lordship.
There are two judgments of the Supreme Court on that point. One in your favor, another in his favor.
Your lordship.
So now we have to balance it.
Another Supreme Court has said every day is
That has been deprecated in the subsequent judgment. Then in the subsequent judgment, the apex court has held that if it is delay, if it is to be explained, then why not hourly? Why not minute by minute? The Supreme Court was very critical in the subsequent judgment. If you want, I can give you. So there is no difficulty. Now it is really a symmetry of the facts. It is no longer eccentric that the court must adopt a lenient approach in finding out the sufficiency of the cause shown in the application, and should not adopt a pedantic view in order to find out the lapses and the gaps, if not the latches, on the part of the litigant in approaching the authority within the statutory period provided therefore. Considering the facts as above, the order of the appellate authority is hereby quashed and set aside. As a consequence whereof, the application for condonation of delay stands allowed. The appellate authority is directed to hear out the appeal on merit after affording an opportunity of hearing the respective parties or their counsels in accordance with law. We expect that the appellate authority would give priority to this matter as it is pending since long.